make sure that your name on Zoom is your first and last name, or at least your first initial last name, to make sure that we can get you promoted. That'll allow you to use your microphone and camera for the remainder of the meeting. But I want to start by saying welcome to the kickoff meeting of the Extremism and Mass Violence Task Force. My name is Jamie Tugendberg. I am with the Anti-Hate Policy Team at the Attorney General's Office, and I will be the lead staff person for this task force. I'm joined by some of my colleagues from the AGL Anti-Hate Team, and they will be introducing themselves when we go through group introductions. I'm going to start with just some meeting logistics, and then we'll go through the agenda. And then we are very lucky to be welcomed by Senator-elect Ramos, who will be giving us some opening remarks. But to start with some meeting logistics, as I've probably noted already a few times, we are in webinar mode. So task force members, again, you're going to be promoted to panelists, which will enable your camera and your microphone. Once we get to the public comment period, for those who signed up in advance of today's meeting, if you are attending remotely, which I believe the majority of those who signed up are, we will also then be promoting you to panelists during that time. So you'll get a notification during that public comment period. And again, that'll enable your microphone and camera. For those of us in the room, we use a central microphone. So it's going to pick up kind of any background noise. So just ask that we kind of try and limit background conversation to the extent possible. And when we do public comment, we will call everyone's names clearly to make sure that if we have individuals in the room, they are able to make a comment as well. And then we would just ask that you step a little bit closer to the camera so that everyone can hear you. So moving on to today's agenda. Like I said, we're going to start with some opening remarks from Senator-elect Ramos. Then we're going to have time for the task force members and staff to introduce themselves. Next, we will learn what this group is expected to accomplish in the next 2 years, to discuss the plan for meeting set objectives, before hearing from members of the public who signed up in advance of today's meeting. Then we'll be having a training on the Open Public Meetings and Public Records Act, and here's some guidance on personal safety and security before we close with next steps. And I'll just pause now and see if you have any questions on the agenda from members of the task force this morning. Okay. Well, hearing no questions, I will now turn the floor over to Senator Ramos.
Well, thank you very much. I'm very happy to be here today with you all as you kick off this task. Just a little background on how it got to here. A few years ago, I got involved with a number of people in the community asking for protection from police officers and sheriff's departments and so forth. And they weren't being responded to. Law enforcement was not responding to them to protect them from others. And we've seen, you all know the various violence we've had in our society of folks against other folks, not for a particular known reason, a personal reason. They had a personal fight, but just because of some idea that violence is happening on streets. And I didn't understand that. So I started talking to people to figure out why and what are we doing about that. Under the United States warnings, they say that domestic intrinsic extremism and violence is our most important concern in our country, but I found nobody doing anything about it. I reached out to various groups, FBI, Department of Justice, Attorney General's Office, local law enforcement and county sheriffs and so forth, and found just not a lot of action, but also people not knowing what to do about it. It's like, how do you stop something? You're not sure what's causing it and how it's happening and so forth. So, tired of hearing thoughts and prayers, go to folks after something. After I kept talking to folks and couldn't figure out I could wrap my arms around it. And if I couldn't do it, how could other folks? So I said, we have to look at this and figure out, we want to get in a preventive mode here to stop those things from happening beforehand, and figure out what's going on in our society to have that. We seem to have that more than other folks do. So the goal was, if we don't understand it, at this point, we don't know what to do to stop except reporting it after the fact. That doesn't work for me. I said, we have a lot of experts in this state, and I think we could have some good discussions and look to some possible recommendations that you could give to us in the legislature. That's your task, in my mind, to give us recommendations as you study this. What could we do to help prevent the things that are going on now that are causing violence in people's lives? And it's as simple as that, is what's happening with us as a society that's causing that, that's different than others. And I know that there's some of this stuff has been around our country for a while. We've got some intrinsic stuff, I think, that is different from other countries as well. But that doesn't stop us from trying to work to have discussions. And again, this is a task force to come up with recommendations. You know, and some folks thought you're going to come up with actions you're going to do. Your job is to bring us recommendations in the legislature so that we decide which ones may be helpful, maybe not, what ones we can enact in a safe and sane way, and bring our communities into conversation. That's the goal. The only way to get through things is to have the tough conversations, sit at the table together, and work through it. And so that's my goal. My task for y'all is not an easy one. I thank you for stepping up to take on this task, because it's not going to be easy. But I look forward to hearing your discussions through this time and what you get to it final.
Well, thank you so much, Senator-elect Ramos, and congratulations.
Thank you.
We appreciate your support, and we appreciate you attending today. Feel free to stay as long as you would like. We're now going to begin with introductions of the task force. I'm going to be going in order of alphabetical, just by first name. Also note we have a couple individuals who are stepping in as designees this morning. So I'd also just ask that you introduce yourself and your organization. And as we go through our introductions, please let us know your name, how you would prefer to be addressed, what interested you in serving on this task force, and what you hope to learn from others as we work together. And I apologize if I missed somebody. We have been having people jump in. So I'll go through the list, and then I'll make sure to call on and see if I've missed anyone who are expecting today. But to begin, we have, I want to make sure, we're going to start with Amber Nguyen.
Good morning, everybody. I am Amber Nguyen. I'm the Office of Superintendent of Public Instruction. I am the lead program supervisor supporting both comprehensive school safety and threat assessment for our K-12 system. Thank you for inviting me to be a part of this. I look forward to working together and as a community, and how we can be a bit more preventative about how we protect our communities, but also our schools.
Thank you, Amber. Amy?
Good morning, everyone. I'm Amy Gillespie. I'm the acting director at Pierce County Department of Emergency Management. Very excited to be a part of this. At Pierce County Emergency Management, we are leading the effort around targeted violence and domestic extremism prevention programs, and really excited to bring that knowledge to this group. So thank you very much for this opportunity.
Thank you, Amy. Danica?
Hi, my name is Danica Benson. I am the Chief of Operations at Freedom Project, as well as Program Director. And I'm looking just to be here to obviously make our community safer, but also I think we all might have a different definition of what safety means to us and you all. So just trying to get community's perspective in this conversation. Thank you.
Thank you, Danica. Emily?
Hi, and apologies for being off camera. I'm at the airport work currently, but I'm Emily Kauffman. I am Associate Director of Investigative Research for the ADL Center on Extremism, and it's really a privilege to be here with you all. Great to see a couple familiar faces, folks from the field, and just really looking forward to being part of a task force that is looking to reduce hate and domestic extremism in Washington State. Grateful to be here, but thank you so much.
Thank you, Emily, and thank you for joining us from the airport. We'll go to Jay.
Hello. Hello, I'm Jay Garrison. I'm Vice President and the founder of the Washington Immigrant Defense Network, and I'm also a private practice lawyer at Garrison Law. I'm here to help with creating rules to reduce hate and domestic extremism directed towards immigrant communities, and as well to help ensure that individuals who are identified as potential threats have a way to challenge that potential designation, because it can have extreme impacts on individuals when they have been incorrectly designated.
Thank you, Jay. Joshua Landers, or Josh, as I see on the screen.
Yeah, good morning. My name is Josh Landers. I work for the Port of Seattle Police Department, where I'm a detective. And I guess I'm just here to better see how we can serve our community, and especially in this respect.
Thank you, Josh. Fawn? Did we lose Fawn?
Did you call me?
I think we called on you, Fawn.
Well, my name is Juan Perales. I'm president of Unidos of Snohomish County, who has been addressing for the last 3-4 years now domestic terrorism and police accountability. And now that we have Trump in power, this issue has become even more important. So I think it's going to take collective action on the part of us to address the oncoming furor of this new administration. Wow. Thank you.
Thank you, Juan. Slightly out of order because we have somebody as a designee this morning, but we're going to go with Ryan Levins.
Good morning, Ryan Levins. I'm the Deputy Director at the Washington State Fusion Center, filling in for Julie Fisher, the Director who is a lieutenant with State Patrol. Just looking forward to seeing what we can do for you guys at the Fusion Center, with domestic extremism being one of our primary focuses here. We're just here to see how we can assist and look forward to working with you guys.
Thank you, Ryan. And I'll just remind task force members who might have just signed on, we're going to be promoting you to panelists here. So Karen, I see you just accepted it. I'll give you a moment and we'll come back to you to introduce yourself, but we'll go to Katrina and then we'll go to Karen.
Good morning. My name is Katrina Johnson. I'm the Executive Director of Black Lives Matter Seattle King County. We are a statewide agency. My pronouns are she, her. I'm here looking for innovative ways and tangible ways to protect our community when law enforcement isn't the go-to people during crisis or when something is transpiring, because it happens a lot with impacted families.
Thank you, Katrina. And Karen.
Hi, my name is Karen Strumgren. I'm with Muslims for Community Action and Support in Spokane, Washington. I'm here just to learn about what other communities are doing and how I can best participate in assisting my community, my Muslim community. Thank you.
Thank you, Karen. And we had somebody who was promoted a little late, Amasai, and please correct me if I mispronounced your first name.
Good morning, everyone. My name is Amasai Cheke. I use she, her pronouns. with Utopia Washington, a queer and trans Pacific Islander-led organization here in Kent. And I'm sitting in on behalf of our policy director, who is currently out of state. And yes, I'm excited to be here and also to learn in ways to strengthen social justice movement. Thank you.
Thank you. Kate Bitts.
Hi, I'm Kate, she, her. I work for Western State Center as a senior organizer. I am just here to bring some perspectives from the field and learn more about what we can do to keep people safe in Washington.
Thank you, Kate. Kira?
Kira Kazanjian, and I am the Director of Facilities, Safety, and Security for Jewish Family Service. And I'm thrilled to get to learn from all of you and work together to craft some recommendations for the legislature. Thank you.
Thank you, Kira. Leslie?
Thank you. I'm Leslie Cushman. I'm here on behalf of the Washington Coalition for Police Accountability. I use she, her pronouns. We do statewide policy work. I'm the policy lead for the coalition. We do statewide policy work on police accountability and look for ways to reduce violence from police. And we're worried about the mainstreaming of extremism. We're worried about law enforcement affiliation with extremism and how this impacts community safety and well-being and how it impacts the rule of law. And I'm really happy to be here. Thank you.
Thank you, Leslie. Luis?
Good morning, everyone. Luis Moscoso. I'm a former state representative on the Public Safety Committee 11 years ago, where I first tried to bring up this issue of looking into militia movements and other activities. I have had direct experience with militia people going back over 30 years in Snohomish County, where I used to live. I've also worked on social justice groups up there, and especially with Juan Perales over the decades. Juan and I were two of the first people to approach Senator-elect Ramos 4 years ago about this matter when the mission to have a proviso to start the research that was done by the AG's office leading to this task force. I presently live in Thurston County. I'm the Government Affairs Director for All Aboard Washington, and I am looking to work with local people down here to, at this level, to look at some of the things that we can do to pay more attention to the work this task force is doing and what the legislature might do in the future. Thank you.
Thank you, Luis. Mary?
Hi, my name's Mary Hall. I'm the Thurston County Auditor. I look forward to serving on this committee. I think we really need to take a deep dive into how we protect our communities in this incoming administration, and not only the community, but election workers. I think there's a lot of underlying tension that, we need to address, and hope to be very proactive and build a lot of partnerships within our community and work with Luis.
Thank you, Mary. Matthew?
Good morning, everybody. My name is Dr. Matthew Schumacher. Please don't call me doctor. Call me Matthew. My background's a little bit complex, but I am currently the principal investigator and clinical director of Parents for Peace. Parents for Peace is a nonprofit organization that runs, as far as we know, the only de-radicalization or response program to hate crimes, ideological fixatedness, people that have committed hate crimes or terrorist offenses, whether they're in the phase of becoming someone that is about to be violent, in which case we try to prevent, or whether they're in any stage of the adjudication process, including in prison, we will work one-on-one with them and their families to decrease risk and to de-radicalize individuals. A couple other little things to say about why I'm here. I am on the FBI's National Hate Crimes Task Force. I was also for 6 years up until recently an embedded psychologist in the Intelligence and Joint Terrorism Task Force at the Sheriff's Department in Los Angeles. So basically all of Southern California. I went through the George Floyd protests. I went through all of the violence, all of the conflict, and even to a certain degree, some of the folks that may have been problematic inside law enforcement on the front lines for about that last 6 years. So what do I hope to get from this task? Well, as the senator-elect said rightly, no one seems to want to do anything often. That's why I left law enforcement. I was able to respond to the hate incidents that occurred against HBCUs. Here it was Charles Drew University. So we went out and assessed their need. And then with elections and changes in atmosphere, I was barred from any longer going out to do those assessments and to provide those services. So I left the department. Parents for Peace, I think, is an elite, very sophisticated approach to handling individuals that are radicalized, terrorists, ideologically violent, things of that nature. But I would not want you to think that that's the only experience we have or our only interests. We're very interested in finding out how we can go with you and protect people or respond to folks that are victims.
Thank you, Matthew. And now we have some folks in the room. Mercedes.
Hello, everyone. I'm Mercedes Sanchez. I'm the Executive Director of Cedar River Clinics. We're reproductive healthcare clinics here in Washington. As abortion providers, of course, we're very concerned about these issues because we have seen an increase in aggression. And we can imagine it will only get worse. And also personally, I've been impacted by terrorism and mass violence. So I'm really looking forward to working with everyone. And as Senator Ramos said, we need to move beyond thoughts and prayers to action.
Thank you. Nathan?
Yeah, good morning, everyone. Nate Reed. I use he, him pronouns. I work at the Washington State Department of Health, where I serve as the Chief of Resiliency and Health Security. Over the years, I've had a lot of opportunities to work with some of our federal partners at the Department of Homeland Security around this idea of using public health approaches to address extremism and domestic violent extremists. And I think at some point, I think it was while the proviso might have even been being developed, someone reached out and said, hey, tell us about public health approaches. And I said, well, that sounds like a great idea. So today I'm here and look forward to learning and hopefully be able to share what I can from that perspective.
Thank you. Roger?
Hi, yeah. I'm the director for a small NGO called Projects for Civil Society, but we are part of a network of violence prevention groups that is doing work in over 60 countries. I've got colleagues who've worked with people from Al-Shabaab, Boko Haram. We have work in Rwanda helping rebuild communities between perpetrators and victims. Locally, we have 20 years. I've been going into Monroe prisons for 20 years and have helped maybe 20 to 30 white supremacist leave groups like Aryan Families, Aryan Nations. And we also do violence prevention in schools in the Highland District right now. So we are both about helping people leave the movements, but also doing preventative work at younger ages that diminish the chances of recruitment.
Thank you, Roger. Seth?
Hello, everybody. I'm Rabbi Seth Limmer. I serve currently as the Director of Public Affairs for Peril. My pronouns are he, his, and I much prefer being Seth to being Rabbi Limmer. There are many things that interested me in serving on this task force. My work with Peril, as the name, the Polarization and Extremism Research and Innovation Lab, we're all about coming up with public health prevention style interventions to reduce the possibility of people being radicalized to mass violence and to give communities the tools that they need to be resilient to extremism. And I also came to this work because back in my pulpit days, I was appointed to the Illinois State Commission on Discrimination and Hate Crimes, on which I continue to serve. And in my own state where I live of Illinois, we're pursuing this same subject of how is it that we can mitigate the effects of extremism and mass violence. So I'm really excited to be here. I'm looking forward to come to know the state of Washington better and to learn about a variety of approaches that we can help your great state implement to confront this major problem. Thanks.
Thank you, Seth. Shannon?
Hi, good morning. I'm Shannon Poe. I'm the Director of Exit Programming for Light or Hate. We're a tertiary intervention provider for individuals who are seeking to leave hate groups. And we also work with law enforcement and prisons for individuals who are mandated to us. And I'm excited to be here and work with you all to see how we can be a resource to individuals within your communities that may be seeking to leave or are finding themselves involved with law enforcement, and we can provide an avenue for them to seek help and find a better life. Thank you. I'm excited to be here.
Thank you, Shannon. Sharon?
Hi, good morning. My name is Sharon Navas. I'm the co-founder and executive director of the Equity in Education Coalition. We are a public policy organization that looks at education policies, implementations, and the school to prison pipeline through a lens of anti-racism. And my interest in joining this task force is the radicalization of our youth in the public education system.
Thank you, Sharon. And William, we're going to be promoting you to panelists here in just a moment so that you can introduce yourself. And we did have a couple members who are not able to make it in attendance today, so we'll make sure that we do another round of introductions at our second meeting, recognizing there's also a large number of people in this group. But William, I see that you were able to make it to panelists. If you could unmute and introduce yourself.
Thank you. William Hairston, Center for Children and Youth Justice. I oversee our impact programs, which includes our CVI work, which is our community violence intervention and prevention work, and that oversees and our support to the Regional Office of Gun Violence's Regional Peacekeepers model, as well as the BJA-funded LINK work, which is our Group and Gang Violence Assistance model. So we kind of come to this work holistically in a way in which we see our young people being moved into different spaces, whether that's group or gang, in any capacity, and look forward to being of service.
Thank you, William. So in addition to staff at the AGO, we are also thrilled to be joined by Cynthia Miller-Idriss from the Polarization and Extremism Research and Innovation Lab on contract to help this task force develop its recommendations. So Cynthia, would you like to introduce yourself?
Sure. Good morning, everyone. I'm Cynthia Miller-Idriss. I'm a professor here at American University and the founding director of the Polarization and Extremism Research and Innovation Lab, which designs and tests and scales up tools for communities to help prevent persuasion by harmful propaganda, conspiracy theories, and other kinds of content. And I'm here as an advisor. I'll be talking to you later today about some advice on personal safety, and you'll have some handouts on that. So I'll be around, not an official member of the task force, and also have been advising this process for a couple of years and really excited to see this room of people, which I think is just an incredible testament to what's happening in Washington State. So very thrilled to see the diversity of perspectives here and the range of things that we'll have in this room, which is really a public health approach that no one else in the country has, I think, forged. So very excited to see it and grateful to you all for being here.
Thank you, Cynthia. And now before we move into the next part of the agenda, I'm going to have some staff from the anti-hate team who will be assisting this task force over the course of the next 2 years introduce themselves. So Mena, would you like to go first?
Yeah. Hi, everyone. My name is Mena Ogamal. I am an anti-hate policy analyst on the anti-hate team. You've been receiving lots of chat messages from me. If you are a member of the public who signed up before our 8 a.m. Deadline this morning to provide oral comment, please just make sure that your first and last name match the first and last name that you signed up with so that we can allow you to speak during the designated public comment period.
And Saba?
Good morning, everyone. I am Saba Azami, she, her pronouns. I work as the Anti-Hate Policy Manager in Policy Division at AGO. Nice to meet you all.
Thank you, Saba. And I do notice we have some hands raised from attendees in the public. I'll just note we do have a designated public comment time. It'll be at 10:30 and registration closed for that at 8 a.m. this morning. And there'll be opportunities to make public comment at future meetings should you wish to. And we'll be going over the protocols here in just a moment to give more information for the next meeting. But again, just thank you all for joining us this morning. We are now going to be going through the draft charter as well as the tentative meeting schedule that were sent out to the group in advance. And we're also going to be sharing them on our screen right now so that we can go through them together. Beginning with the charter, this is a draft document that ultimately the group can amend, and ultimately you will need to vote to approve this charter. So we're going to walk through it this morning just to make sure everybody is comfortable. And this charter communicates the group's scope of work, its authority, the membership, code of conduct, and what you can expect from staff going forward. So beginning with section 1, which covers the authority and scope of the group. This task force was authorized via the operating budget. And the objective of this group is to make legislative and policy recommendations to establish a comprehensive public health and community-based framework to combat domestic extremism and mass violence here in Washington State.
Mass violence?
No aspect of this proviso is to be construed as a directive to alter any aspect of criminal law, create new criminal penalties, or increase criminal law enforcement. The task force will submit a preliminary report in June of 2025. Otherwise, we would have missed that deadline. And its report will be in December 2026, which is the time that the proviso stipulates the group's work will conclude. So I'll just pause now and see if there's any questions from task force members on the authority, the purpose of your work, or the scope and duration. And for members of that are on Zoom, feel free to raise your hand or just jump off of mute if you have any questions. Yes, Roger.
If I might, that clause there, that no aspect should be construed as a directive to alter any aspect of criminal law, etc. Is that read as not being directed, or is that read as a prohibition that we are not to make suggested changes in criminal law?
So that is language pulled directly from the proviso. So it is recommending that this group not make recommendations to change criminal penalties, increase criminal law. And that stems from the recommendations from the 2022 domestic terrorism report that the AGO was contracted to do, which found that at that time, the members of that study preferred a public health approach versus increasing criminal penalties or necessarily providing law enforcement with additional resources. So that's a little background on why that language appears in the proviso. Any other questions? Kate, I see your hand.
Yeah, I have a question about the terminology of public health approach. I think that there's a lot of different things that one can read into that or assumptions that we could make based off of that terminology. But it's not clear to me that people who do public health work have had input into what that means to them, or whether this is a topic that people who are public health experts and practitioners see as part of their work. So could we just talk about that a little bit? How are we going to ensure that those of us who don't come from the world of public health know what we're talking about and how to recommend something thoughtfully that fits into this approach?
Yeah, absolutely. So currently, this group has not defined what they mean by that. And so the first few meetings when we go through the project plan, you'll see they're kind of level setting. So January, we'll have sort of an introduction to extremism and mass violence to make sure we're all sort of under common language, common understanding of what it looks like both across the United States and here in Washington. And then I believe it's the third meeting, we're planning to have sort of an in-depth discussion on a public health framework and what that means and what it looks like in this space. I will say we are lucky to have Nate from the Department of Health here, as well as quite a few people who operate within the public health space to help us craft this definition, including Cynthia and Seth from Peril, the Western States Center, Mercedes, Equity and Education Coalition. So,
yeah, the Western States Center is me. So that's why I'm asking. I would not put myself in a space of knowing what a public health approach to this issue is.
So yes, that's why we're gonna make sure everyone has a common understanding going forward. But there's no necessarily definition in the proviso to give this group guidance. So it'll be kind of up to us to have those conversations on what we mean by public health and community, and also community-based framework as well.
Great, thanks so much for that clarification.
Yeah. Any other questions on this first section? Okay. So we'll move on to section 2, which talks about the membership. So after the meeting, we'll be posting the membership list of the task force to the website, and the finalized charter will include that link. So we're going to encourage members between now and the next meeting to look at the list on the website, and please let us know if you would like to see any changes to how your name or your organization might appear. But for those who might be wondering why the link to the website doesn't actually show the membership list yet, it's coming soon. Moving on to the code of conduct, which was we will be sending out after this meeting and asking task force members to return. But we want to recognize that over the course of the next 2 years, the contents of this group's work will cover really critical issues for both here in Washington State, as well as beyond, in our communities and in the organizations that you represent. So working together, building trust, and honoring the relationships within this task force and our communities will be integral to the work and serving those who are affected by extremism and mass violence. So as such, we expect members to work respectfully with staff and other members. Can you see that? Attend and participate in all scheduled meetings, or reach out to staff and communicate if you're going to have a designee or proxy in your place. We ask that you respond timely and by identified deadlines to communications from staff. And we also ask that you not make any statements or act on behalf of the task force independently. And so just to clarify and add some additional information to that, this means if a reporter were to ask you about the task force's work, we would ask that you notify staff and that you would not make any statements on behalf of the task force's work independently. Those decisions come as a quorum of the membership. We ask that you keep the AGO staff informed about all communications, potential media interviews and appearances, as well as any other business related to the task force's work. We also ask that you share relevant information about this work with your constituency. The goal is to create a community-based framework. You all represent organizations that work within the community, and we want to make sure that the word gets out about this task force and that we're sharing the work that's being done here. And we're going to utilize you all to make sure that we get the message out. and work with us to make sure that we can do additional outreach as well. We ask that you not use your position on this task force for personal or organizational gain, that you identify any actual or potential conflicts of interest that arise, and you recuse yourself from participating in any voting or decision-making that could give rise to conflicts of interest. We ask that you be courageous in challenging biases and previously held beliefs, not engage in comments that perpetrate negative stereotypes about race, gender identity, sexual orientation, mental health status, housing status, political affiliation, or religious beliefs. And we also ask that you prioritize the care of other members, the community, and yourself and your families. In return, members of this task force can expect that staff from the Attorney General's office will provide administrative and staff assistance to the task force and any subcommittees that are created. We will provide the necessary direction and guidance to subcommittees in their work to advise the task force on findings and recommendations. We will provide oversight and coordination of the members and subcommittees of the task force. And we will oversee the development of the 2 legislative reports as required by the authorizing proviso. And finally, we will provide ongoing opportunities for task force members to work with staff to identify areas in which we can improve the task force's work. I'll just pause now and see if anyone has any questions about task force member expectations or what you can expect from staff. Okay, hearing none right now, feel free to ask later. We're going to keep moving on to the section discussing removal of members. So violations of this code of conduct may be used as due cause to remove members of the task force. Violations of the code of conduct should be reported to staff as soon as possible after the incident or incidents. Removal of members will be decided by a simple majority vote of appointed task force members at the next scheduled meeting. Additionally, the Attorney General's office reserves the right to remove members for violations of the above code of conduct following communication with a task force member, including written notice to inform them that their code of conduct is in violation of the code of conduct. So moving on to what non-members of this task force can expect. So these meetings are open to the public, and the facilitator will allow for comments from non-member attendees, provided that they sign up for public comment at least 1 hour in advance of the meeting. Written comments are accepted at any time, and staff will read written comments received up to 1 hour prior to the task force allowed during the public comment period. I want to flag that we had some requests from individuals in the audience today. We have had 8 people sign up for public comment, 4 to give oral testimony, and 4 have submitted written testimony, which staff will read aloud. We have allotted 10 minutes to public comment, and we were planning on providing those who provided oral testimony with up to 2 minutes, and then reading the rest of the public comments that we received. But I want to propose to the group if they would be willing to allow these 2 additional members who have joined us in person to use the 2 remaining minutes during public comment period. They would split that, have 1 minute each. And so I just wanted to bring that forward to the group and see what they would feel about changing the protocol for today's meeting and opening the floor to 2 additional registrations. Any concerns? You can also just thumbs up if you agree with me online. I see 1 thumbs up. I see a hand raised. Okay. So it seems like we have consensus. I'm not hearing any objections, so I'm going to take that as we have some consensus that we will allow these 2 additional people to make public comment this morning. But I just want to remind people going forward that if they would like to sign up for public comment, it is available. Information is on our website. including the email that you would sign up with. Luis, I see your hand. Do you have a question?
No, hit the wrong button.
Just wanted to make sure. Okay. So are any last questions to this section about expectations of task force members, expectations of staff, the removal of members, or open public meetings? Okay, hearing none, we will keep the ball rolling to section 3. So after today's meeting, meetings are expected to last 2.5 hours and will not extend past the time as stated on the agenda without consent of the majority of members in attendance. All meetings will be hybrid with webinar settings, with Zoom options for our virtual attendees and space at our Seattle AGO office. When task force members get to the point of making recommendations, any member can submit a proposal to the group to consider. We will then have an open discussion and a vote on each item. Recommendations will be adopted by a simple majority of the group, and proxies in limited cases may vote for members. However, these intentions must be made known to staff at least 2 hours in advance of meetings, and we really request that proxies are only used when absolutely necessary. Any questions about hybrid meetings at this time? Okay. Now for meeting decorum. Okay. So, as I mentioned, we have hybrid meetings. So for our video conferences, we ask that you mute yourself when you're not talking, you be on camera to the extent possible, you use your rename function to post the name you would prefer to be called, and your representing entity in the meeting. That you limit background distractions to the extent possible, let each speaker finish their thought, and use the raised hand functions to request a turn to talk. Additionally, these social practices will help ensure the task force's productivity. We ask that you seek multiple perspectives when we have conversations, maintain a flexible and open mind, listen from the speaker's point of view, confront ideas, not people, pose questions rather than disagreements, respect time limitations, and work towards consensus and our shared purpose and common interests. Are there any comments or suggested revisions to this meeting decorum? Are there any other social practices that people would like to see we engage in this space? Okay, well, we will have an opportunity to revisit this at any time if people would like to. Oh, Jay, I see your hand raised.
My apologies for thinking of the question belatedly, but do we have any distinction regarding comments while having discussion written into the webinar chat space as opposed to spoken orally?
So we do not have chat enabled. So comments that will be taken for the record will be submitted prior to the meeting, and those that we accept up to an hour before will be read during the public comment period. If we receive any after that deadline, they'll be read at the following meeting.
The question is including for panelists, since panelists can make comments in the chat space currently.
Oh, sorry. Can you repeat your question then?
How do you prefer panelists to use the text chat space? I guess would be the simplest way to ask.
Okay, thank you. Thank you. So we ask that you limit to the extent possible that you use the chat. However, we recognize that you might have mic issues one day There's a lot of things that can come up where the chat can be a flexible tool. You just want to make sure that you're staying germane to the topic at hand. Sometimes we might do polling questions through the chat. But other than that, we ask that you sort of limit that, as that can be a distraction to others during discussions as well.
Thank you.
Yes, of course. And thank you for clarifying. Okay. So keep moving on to the last section. So we're going to have a training later today on open public meetings and public records. The major takeaway is that all communications about this group are subject to disclosure. Staff will provide meeting notes for you to review, revise, and approve with meeting materials for the following meetings. We will endeavor to get materials to the task force a week in advance, and materials, including the agenda and meeting information, will be posted to the AGO's website no later than 24 hours in advance. Are there any questions about communications or meeting minutes? Okay, we are flying through this. So this is sort of an opportunity. We do have quorum here today to adopt the charter. I'm just going to pause now and see if there was any additional questions or revisions that people would want to see in the charter. Otherwise, we can go forward and see if you are ready to adopt the charter here today. And we'll be doing this by unanimous consent, meaning that if I do not hear somebody oppose in the next few minutes, we will be approving the charter.
So I have a question.
Yes.
Does it need to be approved today?
It does not need to be approved today.
Because my question, since we still have sort of a open training or thought on what public health and community-based framework means, I think I might feel just a little better having more information before voting to approve.
Yeah.
Is my comment.
Yeah. And we can always just add this as sort of an administrative item to the following meeting to give people also more time to review, recognizing, you know, it's been a busy week, I'm sure, for many, giving people through January to put more time and see if they would like revisions we can easily do. Are people okay? I see William, I saw a thumbs up. Jay, is that a thumbs up or a comment? Question, okay.
Just a question. We can come back and amend this after we approve it if needed, correct?
Yes, we are able to bring forth amendments to the charter at any time.
Okay.
I am seeing, I think I got Kira, you agree, William agreed, and Mercedes right now to maybe just holding this until January. So unless there's anyone who feels there's an objection. Okay.
I just wanted to flag that panelists cannot thumbs up. So I think the hand raises you're seeing sometimes are in agreement. But just wanted to flag that.
Thank you. That will stop me from being so confused today. So I appreciate that, Emily. Okay, so we will pause on approving the charter for today's meeting, and we will resend it out after today to give you all time to review, and we can have continued discussions on when we would like the charter to be approved. Okay. So we are going to be moving on to the proposed project plan. So staff have developed this plan to help the group meet its legislatively mandated deadlines. The task force will begin with a series of meetings to get a shared understanding of extremism, mass violence, and developing a public health approach. Then the group will have focused meetings on the 3 prongs of a public health approach: primary prevention, secondary prevention, and tertiary. The group will then have a culminating meeting to wrap up on items related to establishing a community-based and public health framework before moving into recommendation discussions and voting. We'll be working with task force members to plan agendas throughout the next 2 years, recognizing you all represent experts in your field and communities. And I saw we had a question put in the chat. Well, Sharon asked if we will be having a set of community and member norms for how we will engage with each other. So we have not established those yet. We just have those kind of high level meeting decorum practices and social practices that are included in the charter. If you would like to see sort of community norms, operating procedures established, we can definitely add that to an agenda item. And I will write down this courageous conversations framework. Sharon, was there anything else that you might want to add? Okay, I will follow up with you so that we can maybe have some for the group to review before the February meeting. Thank you for that. Okay. So kind of just gave a high level overview of the ideas for really high level meeting topics and the course and trajectory through 2026. But recognizing that the impacts of extremism and mass violence are really broad in nature. You know, we have many people representing different fields here today. After our sort of initial 3 meetings to make sure everyone has a shared understanding, we will kind of move into creating potential subcommittees or work groups or whatever the group would like to call them, where we can have really focused discussions on specific policy areas. So just an example that comes to the top of my mind, maybe we have a specific group that's thinking about civic engagement and education, or another one that's looking at, you know, youth prevention. So those are just some ideas to kind of put put in your thoughts now as potential subcommittees, and we'd be looking to you all to bring your expertise to those as well. And those subcommittees will then start to happen in between the larger task force meetings that are bi-monthly. So any questions right now about this project plan through 2026 or some of the ideas and topics for meetings? Okay, well, I am not hearing any questions about the project plan now. And if anyone has questions after today, feel free to reach out to staff, or if there are agenda items that you would like to see over the course of the task force, again, we'll be reaching out to you to work together to put these meetings together to make sure that they're effective for the group and that we're bringing in the right resources as well. And since we are running a little bit ahead of time today, which I love, maybe we will get up before noon and give you all a little time. I think we're gonna just actually take a pause right now for maybe 10 minutes and give everyone a break so that they can stretch their legs. And then we're gonna return for our public comment period. And we're gonna keep that at 10 minutes as per the agenda. And so members of the public who have signed up in advance, we will start public comment at 10:11. And if you are on Zoom, we'll be asking you to join us as panelists at that time for the duration of your testimony. But we will just now take a 10-minute break. Thank you all for walking through the charter and the project plan, and we will see you all at 10:11 for public comment. Okay, welcome back, everyone. We're going to go ahead and get started. All right. Welcome back, everyone. Y'all can hear us. I'm seeing some nodding. Okay, perfect. So like we said earlier, we received signups from 4 folks for public comment today orally, and we have 4 written comments. And like we discussed earlier, we have 2 members of the public who will be in the audience today speaking in person in the room here. So we'll be giving everyone a couple minutes to speak, and we'll time that. So we just ask that you respect the time just so everyone can get a chance to speak. And then staff will read the written comments aloud, and we'll go in order in which we received those signups. And then we, as staff, will read the written comments aloud. And then the folks in the room will speak as well. And they have agreed to split it to a minute each. So staff and task force members won't be responding to any questions or comments made during the testimony. And for those who joined online, we'll be allowing you to talk on Zoom. So just look for that as we call your name. So beginning with our first oral testimony is Emily Anderson in attendance. I'm not seeing Emily online anymore. So Emily, if you are here, Emily Anderson, please use your raised hand function if you don't have your name. Otherwise, we will just move on to the next testimony and come back. Okay. The next one is Rebecca Faust. Are you in attendance? Yes, there we are. You should be unmuted now, Rebecca, or you're able to unmute.
Can you see me?
There we are. Go ahead, Rebecca. Thank you for being here.
Thank you. My name is Rebecca Faust. I'd like to suggest that you start by recognizing what the role of a government is or should be. In a democratic free society, it is not the government's place to tell people what to think or say. It is the responsibility of government to protect people from violence, from violations of their basic rights. The U.S. Supreme Court's decision in Brandenburg v. Ohio may be helpful to you. But let me point this out, please. When folks set up an unauthorized encampment on a university campus, block pedestrian traffic, harass and effectively discriminate against Jewish students, and graffiti hate on public property, and then instead of being penalized, they are rewarded with concessions from the university that incentivizes bad behavior. In closing, I support enforcing laws and regulations against harm to person or property, but respecting free speech and freedom of thought. Thanks for the opportunity to speak, and I look forward to seeing how you proceed in this in future meetings. Thank you.
Thank you so much, Rebecca, for your comments and for being within the time. We appreciate it. Next, we received a public comment request from Joe Kunzler. And please, should be able to unmute. Joe, are you there?
Yes, I am. Can you hear me?
Yes, we can.
All right, thank you. Good morning, Domestic Extremism and Mass Violence Task Force. Joe Kunzler here. I want to thank this task force for coming together as we clearly have a domestic extremist problem in this state. No, I'm not talking about KVI, Keith Yates, Tim Eyman, or Brian Aywood, or Randy Cruz, all of whom I happen to disagree with. Rather, I'm talking about Alex Zimmerman and also the City Council Death Squad that weaponizes public comment to hurl anti-Semitic hate that can start violence. I'm also talking about the anti-Semitic terrorists at the University of Washington that Ari Hoffman reports on. In the case of Alex Zimmerman, he has been launching anti-Semitic attacks in public comment in many places with the Nazi salute, hurling Nazi rhetoric like cockroaches, mocking Jews, and driving with a suspended license. Then there's the prolific anti-Semitic City Council Death Squad, where they attacked Tacoma City Council and Pierce County Council, but got shoved back because those councils came prepared. The City Council Death Squad has also been attacking using raw testimony under city councils. Of course, there's 12 September, where anti-Semitic terrorists decimated democracy at the University of Washington Board of Regents, and yet there has been no prosecution. You should be preparing to recommend actual defenses for public comment to put a stop to this hate. Sound Transit, the Puget Sound Regional Council, the Port of Seattle, the Seattle City Council, the Bellevue City Council, and the Redmond City Council all have strong defenses to deter, detect, and defeat anti-Semitic attacks. I'm concerned, as you should be, though, that defenses against this kind of hate, the kind of hate profile that Tackling Zimmerman, a booklet on Amazon for Kindle and print, could result in silencing legitimate criticism of government and a knee-jerk response. That's why we need guidance from the Attorney General's Office of Washington on how to proceed to stop hate while retaining public comment. We need to keep remote testimony because, as I like to say, we live in a big state with a now medium-sized public transit budget. Thank you for your public service. I will be paying attention to your work. Thank you.
Thank you so much, Joe. And I see that Emily Anderson is back in attendance. If you should be able to unmute now. So if you would like to provide your public comment at this time. Emily, are you there?
Yeah, I'm here.
All right, go ahead, Emily.
I was just, I guess I'm just here to find out what this is all about.
Emily, you went on mute again. Did you have anything more to add?
Yeah, I guess I'm just trying to figure out what this meeting's all about. My service isn't very good here, and I'm just trying to learn some things and see what they're going to come up with and make sure that all parties get a say in what's happening and participate.
All right. Thank you so much, Emily. And hopefully this first session is going to be informative. And thank you for signing up for public comment. The last oral testimony that we have on Zoom is Sharon Demoff, and please correct me if I'm saying your name incorrectly. But Sharon, you can go ahead. You should be able to unmute now.
Thank you. Sharon Damoff, you said it right. My concern is about what measures will be taken to make sure that state power won't be weaponized against citizens. Too often, the government goes after citizens they disagree with politically, such as parents speaking at school board meetings and pro-life citizens. These people have been falsely labeled domestic extremists. Meanwhile, those committing actual violence, such as Antifa, anti-Semitic demonstrators, and trans activists, are allowed to damage property and assault and threaten others. Domestic extremism is a problematic concept because it is easy to label any position you disagree with extremism, especially in a state with one-party control. To keep this from happening, there needs to be clearly defined and significant limitations and standards for whom can be investigated. I am also concerned about the bias hotline going operational in January. Any data collected by that hotline is completely useless because anyone can call and just make up a story. Nothing is verified. Is this task force going to be using any of that unreliable data? Overall, steps need to be taken to prevent weaponization against citizens. Thank you.
Thank you, Sharon. Appreciate your comment. So we've gone through the folks who signed up for oral testimony. I'm going to go ahead and read the written testimony that we received in the order that we received it. So the first one is from Megan Jacob. The comment says, "Dear Task Force Team, this is wrong under our state constitution, Article 1, Section 5, text of Section 5, freedom of speech. Every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. 1, this goes against this right. We should and are under state and federal rights allowed to say freely what we like. Just because this may go against what someone feels does not make it hate or other harmful speech. This is going to cause every little thing someone says be reported that offends. How about you take the money allotted for this and teach respect and decorum on how to respect others' views versus turning it into a nice conversation and not a way to silence people. Thank you, Megan Jacob." The next comment is from Nanette Gemmer, and I apologize if you're online and I set your name incorrectly. The comment is, "What will be classified as hate speech? This sets a dangerous precedent. Who determines what is hate speech? This reminds me of the past 4 years of our present administration, who has weaponized those who disagree with their position. This is a violation of the First Amendment to the Constitution that protects free speech. Sincerely, Nanette Gemmer." The next public comment is from Brian Keene. It says Domestic Violent Extremism Task Force. This, I hear, is your first meeting in the evangelizing the state into the Karl Marx religion of communism that has no end, that only continues to expand. At some point, this email will be considered, quote, hate speech, end quote, and I will be picked up and placed into an internment camp, as so many nations have done, past and present, to their citizens. So the 13 people know more than our founding fathers who wrote the Constitution and are qualified far above our present laws. You know, it doesn't just stop with speech, it also expands to the written word and even what one thinks. How are you going to stop other states from spreading their so-called, quote, hate speech, unquote, into this Washington? So what are you going to call for checkpoints on all roads leading to Washington to scrutinize those entering or leaving by show their papers? And what if a conservative is assigned to your board, what then? Remember, the only way to have complete success is to eliminate or exterminate your opposition. You may have a good laugh at what I have stated, but once you let HB 1333 out of the box, trouble far greater than one can imagine will begin. Thank you for your time, Brian Keene. And the last written testimony is from Erica. We didn't receive a last name. Oh, Erica Engelhardt, thank you. Public testimony regarding the task force to address domestic violent extremism, submitted by Erica Engelhardt, resident of Snohomish County, Washington. In 2022, Bob Ferguson's office spent hundreds of thousands of dollars to fund a 6-month-long study on what he calls domestic violent extremism, quote unquote, in Washington state. The result of the study was a report that offers suggestions, including forming a commission to combat all these awful things listed in the report. The report describes, quote, domestic terrorism, end quote, as an undefined term in the revised Code of Washington, but is defined in the U.S. Code as activities that A, involve acts dangerous to human life, that are a violation of the criminal laws of the United States or of any state, B, appear to be intended to, 1, intimidate or coerce a civilian population, 2, influence the policy of a government by intimidation or coercion, or 3, affect the conduct of a government by mass destruction, assassination, or kidnapping, and C, occur primarily within the territorial jurisdiction of the United States. The report continues, although this is a useful working definition because the statutory term, quote, domestic terrorism, end quote, necessarily includes acts dangerous to human life, it fails to capture the full scope of the problem Washington state faces, which encompasses other forms of extremist and political violence, threats, coercion, and intimidation, online disinformation, extremist recruitment and government infiltration efforts, and the general spread of extreme white supremacist, anti-government, and other ideologies. The bill was never passed through the legislature and did not become law, so now Bob is changing it from a commission to a task force because he is so bent on taking on this battle, which many would argue is an imaginary problem. My family is multiracial, multicultural. Growing up here, I never experienced or witnessed anything described in the report that this whole effort is based on. The report and the testimony given in the legislature last year in support of the failed bill claim that white supremacists are violent and are committing frequent dangerous crimes around Washington, which does not match my experience as a resident of this state. In fact, this state is more accepting and welcoming of people from all races and backgrounds than any other I have been to across the country. The crime problem I see at the hands of the people Bob's office has failed. The ones who have given up hope and replaced it with drugs, which his office is enabling and his policy supports. These people are the ones who end up hurting others or stealing and robbing to feed their addictions. Often these people end up with mental health issues and are stuck on this path of committing crimes to survive. The fact that he now wants to focus on an imaginary problem rather than fix the ones he's responsible for tells me this, quote, task force, end quote, isn't about protecting the people of Washington state. The purpose of this is to persecute and prosecute the people of Washington state who disagree with him. Bob Ferguson wants to further weaponize the government against his political opponents and anyone who has a different opinion than he does and who are not in line with his political agenda. It would appear that he is the one who is extreme and potentially dangerous. This, quote, task force, end quote, should never have been formed, and those involved with it should be aware that the dangerous rhetoric they believe they are combating is the same as the rhetoric they are enabling, encouraging, and participating in. And now we have 2 members of the public. Mr. Iman, you have 1 minute.
Tim Iman. Well, Tim Iman from Bellevue. McCarthy hearings of the 1950s forced regular citizens to be investigated and interrogated for their beliefs, associations, political views, and their friends. Some were jailed and blackballed. Now, at least the McCarthy hearings were in public. Here we're talking about regular citizens and interrogated, not for some illegal act, views, associations, and friends. And there is no judicial oversight no viewing. This offers zero confidence that basic constitutional rights like freedom of association and freedom of expression will not be trampled, and it will all be done in private. House Bill 1333 included criminal penalties just like McCarthy had. Regular citizens should not be deterred from getting together and associating and communicating with one another for fear of being investigated, interrogated, blackballed, and possibly jailed for doing so. This is deeply personal to me. As someone who is targeted and persecuted by the government for my political views, I'm especially opposed to this dangerous commission. I want to make sure that what's happening to me and my family never happens to anyone else ever again.
Thank you, Mr. Hyman.
Thank you, Mr. Eimer. We're going to move on to Ms. Templeton.
Thank you. Thank you, members of the task force, for allowing the two of us to speak. We appreciate that, your consideration. I'm Lisa Templeton. I'm a board member at Informed Choice Washington. I'll call it ICWA. In 2023, ICWA and our several thousand members opposed House Bill 1333, AG Ferguson's bill that sought to establish a commission similar to this task force. HB 1333 sought to combat disinformation and misinformation, address radicalization, and develop public health style responses. It's not that we in any way support criminal violence, quite the opposite. We support law and order, and we peacefully work towards scientific integrity in public health policy and the protection of our civil liberties. What we oppose is the potential for this task force to make recommendations possibly based on political motives rather than actual safety motives that could violate medical and religious freedom, parental rights, and free speech of all kinds.
Thank you, Ms. Templeton. You are at time.
Thank you so much. Thank you both to the members of the public who submitted both verbal comments and written comments today. As a reminder, moving forward, if you would like to make a comment at a future meeting, to please sign up no later than 1 hour prior to the meeting. And we're going to move on to task force trainings and guidelines. So I wanted to introduce Jennifer Steele and Morgan Demeraux from the AG's office, who will be taking us through the training on open public meetings and public records. So Jennifer, you should be a panelist and you should be able to share your screen.
Hey, I am. And I know that Morgan, I don't know if Morgan is here yet. I know that he had a travel conflict. So if he was here, I wanted to let him go first.
I don't think he's here as of right now. So you can go ahead, Jennifer.
Okay, I will head on then.
All right.
Jennifer, we're seeing your, okay.
Yeah, there we go. Just getting it all set up. Oh, let's see. And then I will put this down. Okay. And so I'm Jennifer Steele. I am Public Records Counsel for the Attorney General's Office. This means that I do all things public records. I advise our agency. I defend litigation against our agency, and I work with members of our staff to advise client agencies as well as defend lawsuits against our client agencies. So lots of things, public records, and one of the things that I do are these trainings. So the Public Records Act is a chapter in the RCW. It's a statute that determines and discusses public records. So the Public Records Act establishes that government agencies, the records that they prepare, own, use, and retain are public records. This means that they are open to public inspection. They are open to disclosure. And if a member of the public asks for records or to view records, unless there is a specific exemption that applies that would withhold part of a record or a record in entirety, the agency, the public agency would produce those records. So records are only withheld or not produced to the members of the public if there's a specific exemption in law that applies. Public records are records of the state. They are state property. They're not your personal property, and they need to be retained in accordance with records retention laws, which is another law in the RCW. This transparency allows us to show the public the really good work that public agencies do and allows the public to remain informed of what their agencies are doing for them. So what is a public record? A public record is the term public record and the term writing are both defined within the Public Records Act. A public record is a writing related to the conduct of government or a proprietary function that is prepared, owned, used, or retained, regardless of physical form or characteristics. So it's a very broad definition. The definition of writing is similarly broad. Anything that can capture content is essentially a writing. So photographs, voicemails, paper, anything on our computers, anything that can be captured it would fall within writing. I didn't put the big list up here. Both definitions are quite broad. They're designed to encompass the records and the things that agencies are creating and doing for the public. The location of the record does not matter. The location, it's the content of the record that determines whether the record is a public record. So you might have a file in the backseat of your car, and that does not matter. If it's a public record, it's a public record. It doesn't matter which application it's on your computer. The location doesn't matter. It's the content that determines whether a record is a public record, and you would look to this definition. Public records are state property, as I mentioned. This is the records retention law that establishes that the records need to be preserved, stored, and retained in accordance with the records retention laws. They're not your personal records, even if you created them. If you did so in the capacity of your work on this task force and they meet the definition of a public record based on their content, they are state property, even if they're on or in your personal devices, accounts, or files. And you're required to manage and dispose of all public records only in accordance with state law, with the records retention law. And I have a slide that shows you where you can find the records retention schedules. So is your record a public record? Here are some things to ask in determining whether a record that you're dealing with is a public record. Did you prepare or use this writing for the task force? If you did, it's likely that it's a public record. Does the record have a nexus to a task force decision-making process? So are you referring to this record in your discussions and you gathered this record as part of your research or some assignment that you're doing for the task force and you're discussing it? Does it have a nexus? If so, then it's likely it's a public record. So here are a couple examples. Emails, certainly within and among the task force are public records. But if you're soliciting input, outside of the task force, then if that has a nexus and you're seeking input for the task force, then that is potentially a public record. If you're taking notes of task force meetings, that's definitely a public record. Okay, so it's can be tricky to think through, but always recall and remember that the content of the record is what matters. And if it's related to the task force and there's a nexus to the decision-making process, it's most likely a public record. If you're grappling with this, please ask, and we can help you out and figure out whether a particular record is public record. What do you need to do with these public records now that you have all these public records? You're required to manage, maintain, and organize your records. So keep your records for the task force organized and in a specific location so that if a records request comes in, you're able to access those records and understand exactly where they are, so you can gather all of the records, and we're able to get those records out to the members of the public without any delay. You need to follow the retention schedules. The retention schedules, which I've mentioned several times, establish how long you need to keep various public records. So sometimes a record might be transitory, and that means that it does not have retention value, so you can delete the public record or destroy it. Other records need to be maintained for various time frames, and so you need to follow those retention schedule and make sure that you're retaining and maintaining the records that need to be retained according to that records retention schedule. You need to review public records requests that come in. Records requests will be sent to you if it pertains to the task force and you're likely to have records. So if a records request comes in, review that very carefully, search for records, and provide those records so that we can get them out to the requester. You might need to review those records for any exemptions to disclosure, and definitely do these things in a timely fashion so that we are able to get, again, these records out to the requester. So how do you manage, maintain, and organize public records? As I mentioned, most records you do not need to keep forever. So understand the retention schedule and understand how long you need to retain various records. Like an easy example is scheduling records, like back and forth. I'm available at this time. I can meet at this time. Here's the location of the meeting, blah, 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 blah. Oh, okay, I'm late. I'll be there in 5 minutes. Things like that are unlikely to have retention value. And so that means that you can delete them and you don't need to keep that kind of record. Certainly a record that's saying, here's my draft of this plan that will set all these things in motion, that is a record that might need to be retained a bit longer and likely does. Certainly any kind of final product needs to be retained for likely 6 years or more. You need to copy. An easy thing to do with email, and I believe that's required for correspondence on the task force, is copy or forward the anti-hate email that I have here, anti-hate@atg.wa.gov. If you copy and forward all of your emails to that email account, those emails will be stored on the AGO system, which allows us to the AGO to be the one that's maintaining and preserving and following those retention schedules for those emails, as well as obviously searching and producing records in response to records requests. So on all email correspondence, always CC that address. And if you haven't, then forward it so that the record can be maintained on the state system. As I mentioned, follow the retention schedules and keep folders and files separate for this task force. So if you're, using a particular device, have a folder set up where all records are kept in that particular folder or in a particular file, a particular notebook or notepad if you're keeping handwritten things. Make sure that everything's in the same place and really organized so that you don't have public records permeating in other locations, which can expose those other locations that might otherwise be personal to the Public Records Act in a way that it just becomes a bit, bothersome for people. And also because we really just want to make sure that all of our records are in the same place so that we can find the records that a requester is asking for. So keep things very separate so that you know exactly where everything is. And if you are asked for records, you know that it's going to be in, this location or one of 2 locations or something like that. Just like you have a sock drawer at home or something, right? It would be nonsense to keep your socks in 17 different drawers. That would be very hard to locate the Argyle pair that you're looking for one morning. So it makes a lot more sense to keep all of your socks in one drawer, just like it does with keeping public records in one spot. Searching for records, if you have all those records in one drawer, like your socks, then the search is going to be a lot easier. The Public Records Act requires a search to be conducted in all record locations where it is reasonably anticipated that these records will be found. A search needs to be adequate, and that is judged by a standard of reasonableness. Agencies need to conduct their searches in a way that's reasonably calculated to uncover all relevant records. So understand who searches what, which records are going to be searched centrally. If you've CC'd all of your emails to that email account, our office does do a central email search of accounts that we have access to. So that's an easy thing. Certainly any other records that you're maintaining elsewhere, you're going to need to search for. And where do you need to search? All of the devices, platforms, areas, and applications where those records might be. If they're in the backseat of your car in a notebook, you need to go get that notebook. Follow obvious leads. If you're seeing things that are referring to, seeing records that are referring to something else or a particular person, you need to go kind of track down, hey, is this also responsive to this request? Does this person also need to be contacted? So if you're seeing things like that, follow the leads so that we're getting all the records. Personal devices and personal accounts. We have, the AGO has several policies regarding personal devices and personal accounts, and their use is very discouraged. If you have public records on a personal device or a personal account, they are public records, and they are not your records, even though they're on your personal device or personal account. You may be required to search those personal devices and accounts, transfer the records to the AGO, sign an affidavit of the search and of the records that you found and then that you transferred them, as well as take other steps to ensure that you're preserving records that are on your personal device or account and getting those records to the AGO should a records request come in. So caution is very much advised. If you do have records on your personal device or account that need to be retained, the best thing to do is to get those records to an agency system so that they are preserved on an agency system. So for example, if you have some email on a personal account, if you CC or forward that email to that anti-hate email, then you do not need to keep the original that's in your personal device or account, so long as a records request is not active or a litigation hold isn't active. So if you're doing this in real time as you're creating records and you immediately get them over to a state system, you do not need to continue to retain them on your personal device or account. And so the best practice would be to remove them from your personal device or account so that you are keeping all of the records on a state system, which can be searched, and it's not opening up your personal device or account. I mentioned exemptions. Exemptions are found in law. An exemption needs to be in law in order to withhold or redact information in a record or part of a record. When a request is made and information needs to be exempted or redacted, agencies are required to inform the requester the law that allows that withholding and redaction and provide a brief explanation of why that information is not open to public disclosure. Exemptions are very narrowly construed, and as I said, agencies can only withhold information that is exempt, or records that are exempt in whole, and release the rest of the records. So if we are withholding a record in its entirety, we need to provide that statutory exemption that justifies it, as well as provide a brief explanation. We can't silently withhold things, which would mean, that we're withholding like a file or a record and not explaining that to a records requester. We need to tell them we have this file or this record that is exempt under this for this reason. And the agency always bears the burden of establishing that that exemption applies to those redactions or that withholding. Privacy. There is no general privacy exemption in the Public Records Act. Privacy can be an express element of an other exemption, but for privacy to rise to the occasion of being redacted under Public Records Act, you need to have it be an element of an other statute. And then you need to meet this two-part test, which is that you need information that would be highly offensive to a reasonable person and not of legitimate concern to the public. So keep your personal information out of public records. Do not put your personal information in public records because there is no general privacy exemption. Pick up the phone and have those discussions if you're needing to talk to somebody about a health scare or needing to vent about, something, whatever it is. You don't want to be saying something embarrassing in a public record that you are then going to regret the next day. So if you can pick up the phone, do that. Embarrassment is not an exemption to the Public Records Act, and it is not private information that you have said or done something embarrassing. So pick up the phone if you're concerned. Do not assume that there is a privacy exemption or that you can redact or withhold embarrassing things because that is simply not the case. Failure to follow the Public Records Act is very costly for agencies. It is costly monetarily, but it is certainly costly in terms of loss of public trust, which is a huge thing. We want the public to understand the really good work that we're doing for them. And if we're not following the Public Records Act and being open, then it certainly damages that trust. It's also very expensive monetarily. A court can impose civil penalties. No proof of damage or harm is required. The court considers a variety of factors in determining various penalties, but the penalties range from $0 a day to $100 a day per record. And per day. So of withholding that the requester was entitled to have that record and did not. So penalties get very, very expensive in various cases for a variety of reasons. It becomes a very expensive endeavor. I've mentioned records retention a bunch. This is the records retention law, can be found at 4014. The records retention schedules are held by the Secretary of State, and all of those records retention schedules can be found on the Secretary of State website. Our Attorney General, the Attorney General's office has a specific schedule for records that our office routinely has. There's also the general schedule. So if you're not seeing in the Attorney General schedule how long to retain a particular record, if it's not providing you enough guidance, then you move to the general schedule, the general state schedule, and look and see how long that record can be retained. Once record has met retention, then it can be deleted and destroyed, but not prior to that time. So things to remember, records of government agencies are presumed open. Records and information can only be withheld if there's an exemption in law. Those exemptions are very narrowly construed, and the rest of the record or information must be disclosed. Public records are records that are public based on the content of the record. The location doesn't matter. And public records need to be retained pursuant to those retention laws. And if you have questions, please ask. Any questions at this point?
Mercy, so we have some questions in the room, so we'll go through those, and then Leslie, I see you raising your hand, so I'll call on you. Mercedes, would you like to go ahead?
Sure. So I was just wondering, based on what Jennifer said, is there any thought or plans about maybe having an online drive where we could keep things that could be open to the public records states?
I do not believe that we actually have the capacities at the AG's office to put a drive that would allow internal and external people. So that's why we suggest that you maintain all your records in a single notebook or a single file. Staff is also going to be providing meeting minutes after each. But in general, we're not able to kind of have those capacities just due to data security as well. Jennifer, was there anything else that you wanted to add?
No, really just keeping stuff segregated so that it is all of your task force work is in one location is really the best policy. And then getting stuff to the AGO and on the AGO system when as soon as you can.
Okay, thank you.
Great, thank you. Any other questions from the room on public records? All right, Leslie, I saw you raising your hand. Do you have a question?
Yeah, I had a couple questions. In your slides, you use this word agency, and many of us here aren't agencies, but I assume all of this applies to us because we're doing this work under the Attorney General's auspices. That's one thing. This privacy slide. If you call someone and they take notes about your phone call, does that make it a public record? So and if I took notes during this meeting today, are those notes a public record? That sort of thing. And if you're taking notes for these meetings, maybe we shouldn't be taking notes. I just don't want to complicate my life with a bunch of public records.
Let's see. So I heard all the questions. What was the first one before we got to privacy?
It was about the meaning of the word agency and how that flops over into my life.
Yes. So the Attorney General's office is an agency and the task force is run within the agency. So the task force is subject to the Public Records Act. So yes. Then regarding privacy, the examples that you gave, if somebody is taking notes on a conversation about the task force, then those notes would likely be a public record. If you're taking notes regarding from the meeting, then that's, definitely a public record. But again, if you want to scan, if those notes are, needing to be retained, then you can get those notes to the AGO. So you could wait until the task force, is complete and then send all of those things into the AGO. Or you could just keep everything in one notebook. Really, organization is the key here.
I'll add, Leslie, if you're just taking like working notes, like I want to follow up on X as a result of today's meeting, those are where the retention of that note might not be long term. So your working notes of meetings, so transitory things you want to follow up on, a little note, those all don't need to be retained long term, if that sort of clarifies it. But anything that you're taking notes on that you are going to bring back and present to the group on, or it's going to drive the body's work forward, those are going to have a longer retention period. So your working notes can be you can get rid of them after you no longer need them. But if it's something where you're giving maybe comment on a recommendation that the group will be discussing and you take notes about that, something more substantive, that's what Jennifer's sort of pointing to, might have a longer retention period. So maybe when we're getting to those points where you're taking notes that you want to present to the group, or you're taking notes that you're going to use later to create a work product for the group, those things are the ones that, yes, staff are going to be reaching out to you to compile after the fact. As you mentioned, meeting minutes, yes, we are taking them. They are going to be more high level. So if you do not wish to take notes during meetings, you do not have to. It's really to the degree of what information you want to keep.
Thank you.
And Kate, I see your hand up.
My personal rule on this has always been, wait, did I just freeze? Yeah, my personal rule on this has always been allow the agency to be the one who's deciding how long you need to retain my notes. But is that an unreasonable burden on you if I just photograph any working notes, screenshot any text streams and send them to that anti-hate address? Or are you needing us to personally manage that retention schedule?
Kate, feel free. Working notes, take photos, send it to us. If you, anything that you have a question about that you would rather not, yes, we can run rules on our inbox, so don't worry about flooding it. And then yes, we have staff that when and if we got a request would be able to go through the records and see what is relevant to the request. I will note that if you're texting back and forth, let's say with William one day, and you just are scheduling a phone call, those are items that you do not need to forward to staff. And we would probably appreciate not getting just scheduling emails such as that or scheduling texts. But anything you feel like is more substantive that you just have any question about, feel free to reach out. And you can either call us first before you send it, or you just send it and we can figure it out. But those would be really the only items that we as staff really just don't need to see is you texting back and forth, let's chat tomorrow at 10 a.m. or what's your schedule like next week? Those are really the items that we wouldn't need to see.
Okay, that's helpful. Thank you.
Yeah, of course. And we can, individually work with everyone if there's questions that come up over time about your records or how people would, prefer to keep them on their side versus ours. Just feel free to reach out with staff and we can work with everybody as well.
Hurry up.
Are there any other questions before we move on to the next section of our training, which focuses on open public meetings?
Okay. Yeah, okay. Thank you all for your questions and thank you, Jennifer. We're gonna hand it off to Morgan Demeraux from the AGO, who's gonna talk to you all about the OPMA.
And Morgan, I saw your question. There are 31 members on this task force.
Great, thank you. And that's really, well, the reason I was asking that question is because I was thinking about a quorum, which I'll talk about in just a second here. So thank you all for inviting me to spend some time with you this morning, talking about the Open Public Meetings Act to give you the same kind of good foundation you just got from Jennifer about the PRA. Where I'm going to go this morning, I'll spend a tiny bit of time on the significance of transparency. I think, I was, with the way things developed this morning, I'm traveling, actually stopped in Ellensburg to be part of this. And so the schedule got changed a little bit. So I'll just touch on transparency a tiny bit, and then we'll talk about really how do you conduct business as a governing body subject to the OPMA. I'll give you a brief background into this. Our current basic version of the OPMA was passed in 1971. Prior to that, there was really a kind of a watered down version of what I'm going to present to you this morning, where what people had the right to see was really the final votes. In 1971, there was this move forward to, we want to see the dialogue. We want to see everything develop. And it kind of comes from this idea from Justice Brandeis, who was a Supreme Court justice back in the early 1900s, who was really focused on good decision-making and how do we do that. So in his writings at the time, he's using this quote, sunlight being the best disinfectant. He said, how do we encourage folks to have these frank, open, honest, kind of discussions with kind of an altruistic or higher purpose of the conversations. And obviously, from Justice Brandeis' point of view, consistent with what we see in the OPMA, it's this idea of let's have these conversations in the public view so people can see what's going on, understand how the decisions are made, how we get from an idea to a final decision, or why sometimes we don't make a final decision, or why we choose not to do things. It's really the opportunity to watch the entire process of a cake being baked, or whatever analogy you want to use. So when it comes to the OPMA, going some basic kind of principles behind it, and this is various provisions of the OPMA that I've kind of pulled out and put on the screen. The basic theme of them, though, is what I've been talking about. It's this idea that the public gets to see the actions of the governing body doing its work, and it's not just the final decisions. It's the discussions. It's everything I'm saying, from, hey, how about this idea? And all the debate that happens back and forth as to, is this good? Is this bad? Maybe we should do something different. I was talking with a board member of an agency a little while ago, and this was really troubling to them because they were like, well, how do we, then we get into the public and we look like we're disorganized, like you don't have a plan. And I'm like, and that was troubling this person. I'm like, but that's the exact point behind this. The exact point is you're not supposed to have a predetermined plan. You're supposed to come in with these discussions and have people be able to see, oh, okay, I understand how these board members or task force members felt this way. These ones felt this other way. Through that dynamic of that discussion, we got to a final ending point. The one place we've seen kind of a move forward in the last few years with the OPMA, from 1971 until about a year and a half ago, it was the ability to watch these proceedings, watch the boards doing their work. Coming out of COVID, there was a piece that was added by our legislature where it's not just watching the discussion now. Now there's a requirement at every regular meeting at which final action is taken that there's an opportunity for the public to share their thoughts, their ideas of what we should be doing. In some ways, this is one of those places where it's a legal change, but I think without a big difference. Most agencies were doing this already. Being a new group, you don't have, obviously, that history. But many boards, many city councils, county councils, and whatnot, like I said, we're doing this already with public comment as part of the meeting. And it's just kind of a formalization of that process. So in terms of who the OPMA applies, I'm just going to cover this real briefly, just so you have a kind of a foundation of, if you're outside of this group. It applies to state boards, state commissions. It applies to county councils, cities, schools. Think about those traditional public entities. And it can also go a little bit deeper than that as well. If there's a sub-agency or subgroup of a public agency, it can trickle down into their work as well. And then there's some unique groups having to do with utilities and whatnot that are included in the statute. It's really the first part of this that's relevant to our kind of conversation today. It's this multi-member body created by statute that makes the OPMA kind of apply to groups. Who it doesn't apply to is, and these are specifically called out in the statute itself, the courts, the legislature, they're specifically excluded from the OPMA's provisions. If it is not a public agency, the one common question I get in my role with the AGO is that, what about home associations or youth sports clubs or things like that? Those are not government entities. Those are private organizations. They have their own rules. There's different statutes for HOAs. And I think it's RCW 73 or something right around those timeframes. Or if you're not defined as a public agency with a multi-member body, as a prime example of that, the general work that the AGO does, currently our leader is Bob Ferguson, and it's very soon to be Nick Brown. The meetings that happen as the AGO in general are not covered by the OPMA in terms of the meetings that the AG may have. What makes this group a little bit different is because of the fact it was created by the statute, and so you kind of have to pay attention to both pieces. That's how we got in terms of the OPMA applying to this group. It also, even if you're covered by the OPMA, it doesn't apply to certain activities. I don't think it's likely you're going to be sitting in these roles, so I'll just cover them briefly. Basically, if the board was sitting in as adjudicatory capacity, such as like a land use review petition that we commonly see with cities and counties or something like that, those kinds of issues. Collective bargaining is specifically excluded. Rulemaking as well is specifically excluded. I think it's unlikely that this group will engage in rulemaking, but if it was doing that, there's a specific statutory process for doing that. That's not subject to the OPMA. So digging a little bit deeper, when we get to the basic requirements of the OPMA, basically what it says is that all meetings of the governing body of the public agency have to be open and people get to attend. You can't put restrictions on people's ability to attend these meetings. Basically what that means is kind of what you would expect. It's an open door. People get to walk into wherever the meeting is, have a seat and listen to the proceedings. coming out of COVID, was part of the bill that gave the requirement for mandatory public comment. There's also an encouragement that we continue to use the tools that we're using here this morning in terms of like Team or Zoom, so people can participate remotely, which a lot of people are doing this morning. Because what we found during COVID was that public participation in meetings went way up because of the inclusion or the use of these kinds of tools. And that's great. That's exactly what the OPMA is designed to accomplish. It's not required yet. We'll talk a little bit about structure in a couple minutes here, but it is an encouragement that we use these technologies. So what is a governing body? As I've already mentioned, is a multi-member body. It's a group of individuals, which is why I asked the questions earlier about how many folks were on this task force, and now I know that it's 31. It can go deeper than that as well. If part of this group's work, you decide to create a subcommittee, and that group acts on your behalf. They take public testimony, they take public comment, maybe they conduct a hearing for some reason, or they have some kind of either delegated authority or de facto decision-making authority. Then the OPMA can follow and basically, kind of trickle down to this group as well. When I was talking about de facto decision-making, where it commonly comes up is, if a board is asking a subcommittee to, review grant proposals, or to go look at this group and bring us back the top 5 candidates or something like that, and can effectively eliminate the other candidates. That's that kind of de facto decision making. If the group's work is purely advisory, then it's likely it's not going to be required to follow the OPMA. Another example would be, I was talking with a group of board members from school districts yesterday. And the example I used was if they create a subcommittee to go out and just to survey the kinds of playground equipment that are out there, and what's the safest equipment, give some recommendations back, and just come back to the board and give a report. Not gathering any, not screening out information, just going out, finding information to bring it back to the board to further those further discussions, to encourage those further discussions so the board can be fully informed, not decision-making, not limiting the board in any way as to what it does. Those kinds of actions likely are not going to be covered by the OPMA. If it turns out you're setting one of those up, I always encourage agencies to have a quick conversation with their attorneys, just to make sure they're not inadvertently implicating the OPMA, but just to give you a general framework of which to look at it. So it has to be a governing body. There also has to be a meeting. And meeting is basically where there is a quorum of the governing body, a quorum of the task force that's taking action. I'll talk about what action is in a second. It's basically the work you're doing. It does require a majority of your board members. The nice thing about there being 31 is that means there has to be at least 16 of you on any conversation in order to constitute a meeting. And the reason that is a nice safety net is, some school boards, some counties have 3 commissioners, and so they can't even talk to each other in the community about the agency's business because just the 2 of them having a conversation puts them over this quorum line. And it's not just physical meetings. Obviously, that's the one we think about. But a meeting can happen in lots of different ways, which is why it's nice to have the number so high for this group, because it can happen via email. It can happen via social media. It can happen via text message. It can be serial meetings or running meetings, so to speak, or what's commonly known as a wheel hub, where one person is the conduit for information. In this case, it would have to be to 16 different people. So it can happen in all these different ways. So you do need to be careful about having conversations about the task force business with folks, particularly if it's a group of any size, because you never know how that could play out. There could be other people you don't know about. So just be cautious. I always encourage people to bring the work back to the committee. That's really the best place for it to happen. It doesn't matter what these are called. It can, obviously, if you call it a meeting, that's easy. But if you call it a retreat or a study session, it's really about the conduct. It's really about what you're doing, and not the name that you choose to give it. There is a safety net in here. Simply passively receiving information doesn't count as a meeting. Say a majority of you went to a conference someplace. Your mere presence at that conference wouldn't be a problem, as long as you didn't talk shop, as long as you didn't take action, which I'll cover in just a second. To give you an idea of how this plays out, there was an incident up in San Juan Island where a planning commission, and this is an example of a serial meeting idea, where there's 7 members on this planning commission. 2 of them were having a conversation about the issues. They were still fine. They hadn't crossed this quorum threshold. They looped in the 3rd person, and what they didn't know was that the 3rd person had already had a conversation with the 4th person. And so all of a sudden they found themselves over the quorum line and potential violation of the OPMA. And I think what really helped them in this case was when they realized that there were 4 people, they stopped those conversations. And the court said, there was no intent to have a meeting versus, what the court saw in the facts from what happened with the city of Seattle some years ago now. You may recall that there was a conversation about head tax, and it passed on a Friday afternoon, and then there was another vote, and it passed on Friday with an overwhelming majority. And then on Monday, there was a follow-up vote, and it was repealed. And everybody was like, okay, what happened? How did we get from full forward to hit the brakes that stopped this thing? And what they found through Public Records Act requests was during the weekend, there had been a series of conversations, and the court took that series of conversations to be, and based on what the court interpreted the communications as a collective intent to figure out, okay, what are we going to do, and to have this conversation out of the public eye. So there does need to be an intent. The takeaway, the reason I bring this up is and I think it's probably unlikely with this group because of your size, but if you do find yourself that all of a sudden you inadvertently have stepped over the quorum line, best thing you can do is stop. Don't say, oh, too late now, we've already got a problem, and go full steam ahead, because what happens next can make a difference. I always encourage, obviously, be conservative with this. It's okay to talk to your colleagues, but really be conservative in terms of those conversations. Again, with the idea that this is really supposed to be a public conversation. People get to see it. Finally, finishing off with this, the 3rd piece of the puzzle, there does have to be action. Action, as it's currently defined in the OPMA, is the work you do. And it's not just the final vote, that is still part of action, but it's everything that leads up to that. It can be the public testimony, the deliberations. It's what I was talking about when I first started my comments this morning about the person who was concerned about not looking like they were organized going into the meetings. That's okay. Like I said, that's what these meetings are designed to accomplish, is people get to see the work that goes into decision making and not just having a final decision come at them, so to speak. Something to keep in mind is that this is triggered whether or not final action is ever taken. There are things that you will discuss that will just kind of end, and it won't ever be a motion to table it. It won't ever be a motion to approve it. It'll just kind of peter out. So the final action is not the determinant factor. Really focus on the discussion. It's the conversations that really trigger this. Final action is exactly what you would anticipate. It was as it was back in 1968, as it is now. It's the final decision making, and maybe with possibly one exception, and I'm not convinced of that. Final action always has to be taken in open session. Even if you can go into a closed executive session, and we'll talk about that in a couple seconds here, you still have to come back out into the public in these open meetings for that final decision. People get to see what the final action is, whether that's a vote or whether that's consensus, whatever it looks like. People get to see where you come down on things. You're not allowed to do secret ballots. You can't write down yes or no on a Post-it note and pass it forward. It's really this is how I feel on this issue, and here's what I think we should do. So keep that in mind as you're doing your work, particularly if you do go into an executive session. I don't know if that's likely in this group, but you could do it. And we'll talk about what's allowed for that. So even if you're allowed to go in, don't try to reach consensus as to what happens in that executive session. That has to come back out into the open session. Because it all comes down to this. It all comes down to the idea of public attendance. These are public meetings. And cutting to the last bullet on here, that means people can record these. Washington is a 2-party consent statute for private conversations. But by definition, these are public meetings, which means if a member of the public is sitting in the audience, and as commonly happens, pulls out their phone and starts recording part of the meeting, that's perfectly acceptable. They're not allowed to disrupt the meeting. We'll talk about that in a second here. But these are public meetings. Like I mentioned earlier, you have to have an open door. People get to walk in, sit down. They don't have to identify themselves. One of the new things we've seen in the OPMA, and this is literally post-COVID, is a new provision that says we can set reasonable rules. You can have reasonable rules of conduct. Those conditions have to be necessary to protect public health, protect against interruptions, public safety, things like that. This is so new. We haven't seen any litigation over this. If you're looking at one of those, I encourage you to talk with your assigned AG about what those look like. And I always encourage folks to look at this from a least restrictive point of view. How can we accomplish our goal and still maintain our meeting? Whether it's heaven forbid we face a pandemic again anytime soon. But this is the kind of thing we can anticipate. We can work through some of these issues. There still is encouragement to use the remote tools, and I'm glad that most agencies I see are continuing to use these. In choosing those tools, there are a few restrictions, a few guide rails. One of them is it can't be a pay-to-play system. It has to be one where people can, like with Zoom or Teams, just be provided a link and be able to watch those meetings. We're encouraged to make recordings of these and make those available online. It's not a requirement. You'll see there's a reference here that there'll be a next slide talking about school boards. I took that slide out because when I'm not talking with school board members, there are some unique rules when it comes to school boards. They do have some mandatory requirements for recording now, but that's not the general rule. So public comment, like I said, is the new piece of this that is a difference without a big change, I think. What is now specifically required, however, is that if there is a regular meeting at which final action is taken, so if there's some kind of an affirmative vote about something or consensus building, at those regular meetings, you are required to take public comment, and you have a choice as how you accomplish this. The first choice is oral comment. This is traditionally what most agencies have been doing, and it's what you'd anticipate. You can set, again, reasonable rules. Most agencies are giving members of the public 3 minutes or up to 3 minutes of time to share their thoughts. Some will put limits on how much time for total comment. Some to say, okay, we'll give you everybody 30 minutes total, and some 60 minutes, depending on the topic. You kind of have to work through that issue as to, and whether it's a hot topic issue or whatnot. But you can put those kinds of rules in place. You also, if you're taking oral comment, there is an expectation, a requirement that if it's reasonable, you accommodate people that have a disability or that can't make it to the meeting because they have limited mobility, or they have any other reason why they can't make it. So if they happen to be on vacation in Hawaii while the meeting's going on, that seems like making physical attendance difficult. Again, this is, there's a duty to kind of accommodate so people can make this happen. Being with part of the AG's office, obviously we're using Zoom this morning, so there's a great tool. I've seen some agencies do it very old school and just have the clerk of the board call that person on a cell phone and really hold the phone up to the microphone so that the public can hear that public comment. There's lots of ways to accomplish this. Again, you can have time limits, as I've been mentioning. You put reasonable restrictions up to 3 minutes, things like that. The other way you can accomplish this is written comment. Again, you can put reasonable rules, things like, all written comment has to be received by 5 o'clock the day before a meeting. The one requirement with this is it does have to be distributed to the governing body, to the task force. And I always recommend that if you're taking written comment, that the board chair, as part of their opening colloquy, says, how much public comment that was received, and that is distributed to the board as of 9 o'clock this morning, 8 o'clock, whatever that fact is, and have that entered as part of the minutes as well, just so you can prove you met your obligation when it comes to this. So that's the basic kind of how meetings happen. Now I'm going to tell you a little bit about the kind of meetings there are, and it basically comes down to 2 different kinds of meetings. One of them is a regular meeting, and regular meetings are the ones that happen because this is the schedule you decide on, whether it's published in the WACs or whether it's by just the procedures you develop. If you decide that you're going to meet every quarter, the first Tuesday of every quarter, those are regular meetings, whatever that schedule may be. You have some affirmative obligations in preparing for those meetings. The biggest one is you have to put out an agenda, tell people what work you're going to be doing. That has to be published on the website 24 hours in advance. The thing with regular meetings and the agenda is that agenda can be changed. I always encourage folks to approach this cautiously because when agendas keep getting changed and changed and changed, obviously you can, I suspect they appreciate this causes the public to think, wait a second, I didn't know you were doing this. I'm seeing a bait and switch. It just helps erode trust. But it is perfectly legal to do it, but I always encourage a little bit of restraint. And if you're adding something to an agenda, And when I'm working with my boards and commissions, I typically ask the question, is this something that can hold for a special meeting or till the next meeting? And maybe it can, maybe it can't, but have that thought. There is a little bit of protection in here for you. If you get the agenda, if you miss your agenda a little bit, it doesn't get posted 24 hours in advance. That doesn't mean everything you do at the meeting is invalid. There was, I think, a recognition that, as I think everybody's experienced, technology is not always perfect, and sometimes we get things on the websites crash, or it's up posted 23 hours in advance versus 24 hours in advance. There is this protection. Obviously, I encourage folks to do their best to make it. I haven't seen a lot of problem with it, but that is a common question that I get from folks. There is an exception for small agencies. I'm not going to spend a lot of time on that. If somebody out there is working for a small agency as a board member or whatnot and wants to talk about this, like I was talking with the school boards and a school board member from a very small district in Eastern Washington came up and talked to me yesterday about qualifying for this. Feel free to reach out to me. I'm happy to talk about it. But I don't think it's obviously going to apply to the work that you all are doing. So the next kind of meeting is a special meeting. And special meetings are basically any other reason you're getting together. If you decide to have a study session, a work group, if there's an issue that comes up between your regular meetings that you need to address as a group, that would be called a special meeting. It can be called by the presiding officer, or it could be called by a majority of the task force members. This is the one place where task force members are able to talk to each other about work, basically talk shop. But please be careful. Just to talk about scheduling the meeting, we need to get together to talk about whatever the issue is, and don't take that next step of engaging in the conversation, because you will have a problem if you do that. It's purely a license to say, hey, let's set up some time so we can get together to have this conversation. You do have to give notice. It has to be written notice to all of the board members of the time, the place, the business to be transacted. Think about it from an agenda point of view. It also that notice has to be provided to the media if there's a standing request. It has to be also posted on the agency website. And this is more and more what we're seeing as how folks are getting notice of meetings. In addition, it has to be posted at the regular place of business and wherever this meeting, the official meeting, is going to happen. And so that is an additional requirement. Obviously, with the AG's office, our primary location is down here in Olympia. So if the physical location was happening in the Seattle office, we would post it both places. So digging into this idea of what has to be in that notice of meeting, that agenda, you do need to be specific. We've seen a little bit of litigation over this in the last couple of years, where there was an agenda item that said to discuss local control, and this had to do with the school board. And our Supreme Court looked at that and said, that's really not giving enough information of what they're going to be talking about. So you do need to dig a little bit deeper, give people fair notice of what the topic is. And it is a requirement. There's a kind of a hybrid type of meeting. It's called an emergency special meeting. And I can't foresee a place where this task force would have to deal with this kind of a thing. So I'll just cover this real briefly. Basically, if something really bad was going to happen, loss of life, significant loss of property, then a board can meet with no notice, because if you delay, there will be nothing to deal with. Think about the town of Mapton a few years ago. 80% of the town burned in a day. That's the kind of thing we're talking about. Pardon me, economic loss is not sufficient to meet this kind of a standard. Again, I think it's highly unlikely that you'll have to face this kind of an issue. But in the event that one of you sits on a different board or a different commission, there is this. Give me a call. I'm happy to talk about it further with you. The legislature has used the word emergency in two contexts. So there's that emergency meeting I was just talking about a second ago. And then you also have the ability to have what's called a remote emergency meeting. And this is, think about 3 years ago in the middle of the pandemic. This is what we're talking about. When there is a reason we can't get together in one place and have those conversations because of public safety, something like that. There does need to be a declared emergency at either the state or federal level. And then the agency has to make a determination that it can't have that meeting with reasonable safety. And then it has the option of either having a complete remote meeting, harkening back to what we were doing during COVID, or having a hybrid meeting, which is what's happening here today. The one requirement in doing this is that you have to provide a means for people to participate remotely, at least with audio. More and more, we're seeing folks doing this with Teams, with Zooms, or one of these other platforms. This is also different than just participating in a meeting remotely during regular times. There's folks participating this morning from various places. That's not implicated by this. Those kinds of things are subject to your agency, the rules that you develop in terms of how you're going to conduct business. So don't think that just because there's no declared emergency, people can't participate remotely. There's two pieces with this. If there's no declared emergency, there does need to be a physical location of the meeting. And I know the staff with the AG's office is well aware of this. I know there's folks up in the Seattle office today having that physical location. So obviously we're satisfying that, but there will always be a physical location for all of your meetings, even if nobody is present except for one of our staff members or somebody with the AG's office who is making sure the door is open and that people can watch the proceeding in those kind of contexts. So everything up until this moment has been about how do you do business transparently? How do how can the public see what's going on? This is the one area in these executive sessions where you're allowed to have a closed session where the public can be excluded. This can be part of a regular session or it can be part of a special meeting. It doesn't matter which one it is. You are limited to why you can go into a executive session. And these are specifically called out in 423110. It ranges everything from some things you would expect, like if you were going to purchase, probably not like with this group, like the purchase or sale of a piece of property, if having those conversations in public would cause you to either pay more or not be able to get the full value for the property. More commonly, what I see with probably this group is if for some reason you wanted to get some legal advice on something, you can go into an executive session to get that legal advice. There are some parameters behind it. To give you some other examples out there, there is a specific one for national security. But I always encourage my agencies when I'm working with them, and I do this myself, I go back and I look at the statute every time I'm talking about executive session. I use this language in the announcements because the chair of the board does have to announce why you're going into executive session. That has to be reflected in the minutes. Other kind of housekeeping things that have to happen is the chair has to say how long you're going to be in executive session. And once you have kind of picked that number, you can't come back into regular session early. That is the minimum time that you can be out. You can extend that time if you need more. And again, the chair has to come back into regular session, tell the audience that we need an additional 10 minutes, 20 minutes, 15 minutes, whatever that number is. Commonly, this happens with people participating remotely, that they're making obviously to the Zoom audience and to a bunch of empty chairs in a room. But it does have to happen that way. You should also reflect those numbers in the minutes as well, so that you can prove compliance with these obligations of the OPMA. These are just some other ones. There's an allowance for evaluating the applicants for public employment. You can do those kinds of things in executive session. I've also mentioned national security, negotiations of public held contracts. Some of that can be done in executive session as well. But again, when those specific issues come up, reach back out. We're happy to talk with you. I don't know how much you're actually going to have a call for executive session, so I won't go into them in a lot more detail than that. But in certain circumstances, in some circumstances, you do have the ability to have these closed conversations. I'm kind of even a foreshadow of this already with this idea of passively receiving information is not a violation of the OPMA. Kind of related to that, and where it comes from is this idea that a majority say that you're having a retreat, and so 16 of you are going to, 20 of you are going to travel in the same bus to get to wherever this retreat is. That's okay, and again, as long as you don't talk shop, as long as you take no action. And there's an AG opinion on this as well, that you can go to conferences, you can travel together, you can do things socially. And being a large group, you do have some insulation with this, but I'm sure you can appreciate for 3-member city council, this in a small community, this is what still allows the city council members to go to football games or barbecues or to weddings and things like that. Again, as long as they actually don't talk shop, because the second they start doing agency business, then you have an unscheduled meeting and people don't know about it. People don't get to watch the process. There are a couple other housekeeping things. I've mentioned already, and there was a comment as we were starting off as well about the way the minutes are kept. You do have an obligation to maintain minutes of your meetings, absent with the only exception of you're required to put the purpose of an executive session. After that, it's kind of up to the group as to how detailed you want those minutes to be. I've read some that read like transcripts, and I always feel really bad for the board member or for the clerk of the board who has to write those. Other ones I've read are so cryptic you can barely tell anybody who's in the room. I'm more of a fan of issues minutes, where you can see how the meeting progressed, what the issues were, how things played out, things along those lines. They do have to be approved, and typically you'll approve the minutes from one meeting at your next meeting, and not likely to happen with this group. There have been recall petitions against public officials for not approving minutes. It is a specific obligation, and I also include adding some additional information in there. If you're using a remote tool like we're using this morning, put those hyperlinks in there in terms of what you used. I've seen the participation levels kind of vary along the way. When I first dropped on to this meeting, there were about 160 people, and now we're down to 130. Include that in there as well. It just shows the tools are working and that we're being transparent. More and more, we are seeing a problem with interruptions and disruptions, which is unfortunate on so many levels. But there's a plan. You do have the ability to deal with this. These are still your meetings, and my recommendation is that the board chair work with one of the AGs or with the staff to basically have a cheat sheet as to how to deal with disruptions. What's built into the OPMA is kind of what you would anticipate. If you have an individual that is being disruptive, you try to engage with that individual and ask them, please, 3 minutes are over. Would you please step away from the mic? We have other people who want to share their information. If they continue on, maybe you recess the meeting, take a break, and then reconvene. If the meeting is completely come off the rails, you do have the ability to recess to a different location to adjourn the meeting. It does take a formal process. And this is exactly why I recommend the board chair have a red sheet at the back of their manual that says break in case of emergency. There was a town in Eastern Washington that had an individual that they deemed was trying to interrupt their meeting, and they ultimately ended up calling the county sheriff, and the person was trying to record the meetings, and I think that was just an unfortunate turn of events where they were working it through on the fly, and so they made some unfortunate decisions. It didn't play out well for both the county sheriff and for that town. So your board chair should work with us to have an idea of what to do with this. But the key point being, these are still your meetings. Even though we're not required to take public comment at regular meetings, that doesn't mean that you cede control of your meetings. It's the ability for the public to share information with you as task force members. Then this is the so what moment. So why does all this matter? Well, one reason it matters is because it's the law, and I do what I do with the AG's office because I think there's a huge value in transparency and people being able to watch these meetings and to see the records that we're relying upon, that we're writing back and forth. If you get this wrong, if your meetings are subject to the OPMA, you are individually liable for the first knowing violation, $500. For each subsequent violation, each knowing violation, it's $1,000. And then on top of that, you're going to be looking at costs and attorney's fees. So look at if there were 31 members present and there's a knowing violation at $500, you're talking at someplace in the range of $16,000 in penalties to each of you total. And then we'll get to pay the attorney's fees. And I guarantee we do not want to do that. In a public records context, there was a case where the penalty was $15,000 and the attorney's fees were $45,000. Yakima settled the case a while ago now for $13,000. So that does have financial repercussions. More concerning to me, actually, though, as much as I don't want to see anybody ever have to write those checks, is that it could also impact and negate the decisions you make. If a judge has the ability to come back and say, because of the violations of the OPMA, and it doesn't happen in every case, this is something the court can do, the court can say that decision you thought you made was invalid, now go back and do it again. And so it could leave you in limbo if you've made something and had reliance on this and whatnot. That concerns me more than the penalty. As much as I don't want to see, I guess, anybody pay those penalties, having actions overturned is really problematic, or can be as well. And then there's a third option that could happen if an individual was concerned that there was going to be future actions, future violations. They could go to court and ask a judge to enter an order that says, task force, in the future, do not violate the OPMA. But it's the middle one that really concerns me. So with that, if I can answer any questions on the OPMA, I am happy to. But I shall say congratulations to you. You've now completed your required training. You had to do this within 90 days of taking on the responsibility, and then every 4 years thereafter. So now you can recheck your box if you serve on another committee as well, another board. You now have an additional 4 years that you can not think about this. I do encourage folks to take it more commonly or more frequently than that, because we do see changes. But from a legal point of view, you've got a 4-year window right now. If you're on a school board or a charter school, you do have some additional training requirements that are in addition to that. This is for the general population, so to speak.
All right, thank you so much, Morgan. We appreciate the training. Do we have any folks on Zoom who had any questions about the OPMA training? We see a question on the chat that says, I am on a board of directors, Human Rights Spokane as well. How does that affect my participation in this group? Karen, did you want to clarify where that question was coming from?
Come on, Karen.
Hi, Karen. I guess I'll just take a stab at answering. So you're more than welcome to serve on other boards. We just ask, and we have in our code of conduct, if you feel like there's ever going to be a conflict of interest between these two bodies of work, and there might be specifically a recommendation, we would ask that you try and recuse yourself in those positions. But there's nothing to preclude you from being on 2 boards, 3 boards, however many you would like to be. It's just that, how does that work influence this? And then I think kind of talking to a Jennifer, just making sure you're keeping your records really distinctly different and separate for those 2 bodies of work.
Yes.
Thank you. Okay, wonderful.
Did we have any other questions on Zoom before we move to those in the room? Okay, seeing none. Any folks in the room that had any questions? Go ahead.
I'm just curious, do you, just in what we've been talking about, I didn't see any info about setting up an executive committee. Do you imagine we probably won't have any closed sessions with this task force?
Yeah, the majority of the task forces the AG operates do not ever go into executive session. We might create subcommittees or work groups, and depending on the number of task force members that are a part of those groups, they might fall into OPMA requirements, and we might then have those be open to the public as well. But if there's subcommittees that have less members, or maybe we're asking people outside of the task force to participate in those would not be necessarily required to be open to the public, but we typically do. Does that answer your question?
It does.
Kate.
So when we're talking about subcommittees and quorum, does that mean that a subcommittee would have to constitute a quorum of the whole group in order to be subject to OPMA? Or I think I'm getting lost in the math of it all, right? Because the subcommittee has its own quorum.
And that's the way to think about it perfectly. That last sentence, it is that subcommittee is, they take the authority, they take the requirement, and then they stand on their own. Okay, well, how many folks do we have in the subcommittee? And if there's 7 people in that subcommittee, then we have that 4 is the quorum line for that group.
That's very helpful. Thank you.
Do we have any other questions? Otherwise, we're going to move on to Cynthia Miller-Idriss for a presentation on personal safety and security.
Billy.
And if there are any other questions after today's meeting, just don't hesitate to reach out to staff. We can always connect you to Morgan or Jennifer if we're not able to answer your questions. But thank you so much, Jennifer and Morgan, for getting us through these required trainings. We really appreciate you taking the time. So, but again, if there's any other questions about OPMA or public records, don't hesitate to reach out. But now we will turn the floor over to Cynthia.
Thanks so much, Jamie. Can you just confirm, is it okay if folks ask me questions? Do we have time for that if I just take a few minutes, Jamie?
Yeah, absolutely.
Okay.
We can honestly go about 15, even 18-ish minutes. My closing remarks are no longer than 2 minutes, so we have a little bit of time for you to walk it through and if there's any questions.
Online.
That's great. Okay, good. I just wanted to make sure. So
Well, I'm going
everyone
to
should
Fred
have
Meyer
a copy in the documents that you received of a
reactivate your
draft
prescription,
primer on personal safety
and then I'm going to
protection
FedEx,
against threats.
and
I
then I'm
know
going
this
back to
group
Fred Meyer,
is really
and then I'm
diverse
picking
in
up my
terms
car
of the roles
tabs.
you've been in. So some of you have already been doing all of this work to protect yourselves and have faced many different complicated threats. And others will have, this might be a little bit new. And one of the things, as you know, we've seen over the last several years are people who are in civil service roles and public service roles in really unexpected ways, receiving threats and being doxxed, and so from librarians and school board officials. So I welcome feedback on this. If folks want additional guidance, I'm here to support you and to support the team over the coming couple of years. So. And the last thing I would say is there's a lot in here. There's no expectation that task force members follow this guidance. This is just a resource for you to sort of some best practices, some of which can seem very, very stringent, and so take it with a grain of salt and follow what you need. I think the most important thing that we have found in our lab and our research, and for me personally, is to make yourself less findable online if you can. And so there's a section here that's, check how easily searchable you are, check your home address and your information. So try to dox yourself basically, or have a friend or a family member dox you. See how easily your personal information, your address, your cell phone, your personal email address comes up. And then if it does come up, highly recommend subscribing, or if your workplace will do it for you, or personally subscribing to a company like, and I list a few examples here. Privacy Duck is the one that a lot of folks use, or Delete Me, that will remove you from those data broker sites and public databases that are selling your information to others and that make it easy for you to be found. Related to that are things like using a privacy based browser and trying to separate your personal and your professional social media accounts if you can. So that protects your family members, protects images that you may have posted of children or relatives online, and tries to keep that separate. So you may even consider using a different name or a different spelling of your name on a personal social media site, and keeping that really locked down so that you're separating out pictures and information and names about your family members from your own. Then there's a lot of basic security here that has to do with privacy settings, two-factor authentication on all sites. That's one of those things that it helps. Like, the only way I got it done, I will say, is just by having somebody sit with me and go through, like a friend, just sit down and go through every platform and set it up. Just set the time in your calendar and go through it. You might consider, if you don't already have a separate phone number for two-factor authentication, thinking about that, making sure that you're using a password manager or separate passwords for each type of site. And then there's some things that you can do, like a reverse image search on Google to see if there's information or images appearing of you or of your office, if they're showing up in nefarious sites. So again, that's something that you can do. When it comes to actually receiving threats, this is something also to talk about with your offices. If you're not already doing it, we have a protocol in place, for example, when threats get really bad, just for your own psychological safety. If this happens to you, which again, I hope it does not, but if it does, then you can have someone else in your office designated to review and make decisions about that. It can be a little bit easier to have the non-target person be the one reviewing. And so we have systems like that in place, and then make sure there are protocols in place for what to do. How do you escalate it? Who does that go to? Obviously, task force should be informed, but also if it's related to your work, there's a person in your office who receives those threats and makes decisions about the investigation. We have some guidelines here for what to do if your information gets posted online. And I'll also just say, some of the guidelines in here may be different. Those of you who work in public-facing office roles, for the government, may not be able to follow the guidance that someone like me can follow in a private university about not having a work address accessible online. So I would urge each of you to think about and talk with your own offices what you can do, what you can't do, and how you can make sure that you stay safe. Again, I'm hesitant to be alarmist. I hope that none of this is relevant. We always say, it's much better to be prepared and to follow the most guidance that you can rather than be in a situation where caught off guard and scrambling to catch up. So I wanted, to make sure you have that. I've listed some links with additional resources and basically just turn to questions if there are questions about this or about how you can stay safer while serving in a role that might put you out in front of bad actors who want to harass or cause problems. We would, we'd love to support you, and I'd love to provide any more information I can. Does anyone have questions?
And also add, if any individual does receive a threat or a harassing message as a result of being a member of this task force, please immediately contact our team. As Cynthia mentioned, there's protocols in place for individuals to not have to review that themselves. And so we do have a safety team here at the Attorney General's office that we will be able to work with to determine the best ways to proceed, dependent on what the nature of the communication is or the threat. And we just want to make sure that you all know that your safety and security is a top priority to participate in this. And so we just want to make it, really clear. If this does ever come up, please reach out to us immediately and forward the information that you received as well. But yes, if there's any questions, maybe any in the room.
If there's anything else that comes up, anything you'd like more information on related to security and privacy, just at the anti-hate, the staff email, they can forward it to me and I can update this information as we move forward, anything that you might need. And hopefully no one ever needs it. And again, I hope that's not stressful information for you, but supportive information.
Thanks so much, Cynthia. We appreciate it. And like we said before, that document it was sent out from the anti-hate email. So if you wanted to look over it and read over it in your own time, and then if you had any questions you can come back with, please let staff know.
But we have made it through all of our items on the agenda today. I think we are going to get you out a few minutes early. I didn't jinx myself earlier by saying that. I just want to say thank you all for attending and participating. For the folks who joined us in person, we really appreciate you navigating down trees, down power lines in the Seattle area to get here today. We recognize this was pretty administrative and training heavy, but our next meeting, we're really going to dive into the bulk of the work that this task force is going to begin. I will be sending out calendar invites for meetings through 2026. Our next meeting will be Friday, January 10th from 9 to 11:30 Pacific Standard Time. I'm also going to be reaching out to all of the members in the course of the next few months to schedule some one-on-ones so that we can get to know each other slightly better and also understand what questions you might have about the work, what areas that you can contribute to, and how you might want to participate in subcommittees or setting agendas with staff. So make sure to look out for emails from the anti-hate team to schedule those one-on-ones. Recognizing this is the holidays coming up, we will be able to be flexible and continue to have those meetings throughout the entire time we're working together as well. With that said, I just want to thank you all again for attending. We look forward to seeing you in January. If there's anything that you need between now and then, do not hesitate to reach out to staff. And again, we will be reaching out to you. And I just want to say, I hope everyone has a wonderful holiday season, and we appreciate you all being willing to be on this task force and work with us on this really important issue. So thank you all, and I'm giving you 10 minutes back to your day.